This is Class 18, Defenses to Infringement. The agenda for today has 3 items. First, we're going to talk about inequitable conduct, one of the more important defenses to infringement that's available. Then we're going to talk about the defense of experimental use and what the scope of that is. And then finally, a new version of defense that's been enhanced in the recent American Invents Act, which is prior user rights. So diving right into inequitable conduct. Inequitable conduct is a doctrine which considers the patentee's behavior before the PTO. Right? The idea here is this is a doctrine which is supposed to enforce the relationship between the patent applicant and the patent office. And the reason for the doctrine basically is that patent prosecution is an ex parte process, meaning there is not an adversary to check to see that submissions are correct and complete and things like that. And so therefore the idea is that we need rules to ensure that you deal with the PTO in good faith and with good candor, because the PTO is going to rely largely upon the statements of the patent applicant with regards to many of the issues that are going to be dealt with in the patent prosecution process. So the inequitable conduct doctrine in general says that if you misbehave before the PTO, then your patent will be held unenforceable. Unenforceability is different than invalidity. Unenforceability in some ways is more significant than invalidity because it cancels all claims of the patent. It doesn't declare the patent as invalid, but it's essentially functionally the same because you cannot sue anyone on the patent. You can't enforce the patent. Inequitable conduct type behaviors can include misrepresentations, failure to disclose something, or submission of actually false information. Although in almost all cases, the arguments about inequitable conduct are based on either a failure to disclose relevant prior art or some sort of misrepresentation. It's relatively rare that you see a case of just blatant false information being filed before the PTO. And again, the policy perspective is that we want patentees to, as much as possible, engage with, well, not as much as possible, in all cases, to engage with the PTO with good faith and candor, because the PTO does rely on their statements. So in Therasense, the case I gave you to read, which was in the supplement, the Federal Circuit refers to inequitable conduct as the atomic bomb of patent law. And that's an interesting statement, and I think unpacking why will lead you to a sense of how we've gotten to where we are in the doctrine of inequitable conduct. Inequitable conduct is an extremely powerful remedy. If you hold a patent unenforceable, like I said a moment ago, you're going to cancel all the claims, not formally cancel them in the sense that they're invalid, but you're going to make them unenforceable, unavailable to the patentee for enforcement purposes. This is well beyond an invalidity holding, which would apply only to particular claims, right? So if you litigate and sue somebody on the basis of Claim 1, and it turns out that Claim 1 is declared invalid, you still have the rest of your claims, however many there are, that remain in your patent, and you could enforce in theory against some other defendant at some point in the future. Inequitable conduct is different. If your patent is held unenforceable, then forever you are barred from enforcing your patent against not only the defendant in that particular case, but frankly against anybody at all. And so that means this is a very powerful doctrine, and one that is very attractive for patent defendants, right? Because not only is it immensely powerful in terms of canceling out the particular litigation at hand, there are actually cases which hold that in some cases the unenforceability can spread to related patents. So not only might the particular patent at issue in the case at hand be held unenforceable, but it's possible that related patents can be held unenforceable as well, which means an entire family of your patents could be held unenforceable, which, as you can imagine, would cause no end hardship for a patentee. And so because of that, it is an extremely powerful concept, and one that the Federal Circuit has been rightly very concerned about for many years, because the policy implications of having such a powerful attack, a powerful potential defense, is that it gets raised in many cases, even when probably the facts don't justify it. And the reason it gets raised, of course, is because if you can win, it's worth rolling the dice, because if you can win on inequitable conduct, the gains to be had from winning are so significant that it's worth the time, the money, the effort, etc., to try and win these inequitable conduct cases. And so many patentees do try and win these cases whenever they can, and so they raise them. They involve fairly extensive discovery, so they can make patent litigation much more expensive, because in order to find inequitable conduct, as we'll find out in a minute, you have to dig pretty deep into the course of conduct during prosecution among all of the various players involved in the prosecution. So that means that the discovery burden can be quite large. And it slows trials down. You can often have many hearings and a lot of testimony and focus just on the inequitable conduct idea. And for that reason, the court has long been concerned, the Federal Circuit has long been concerned that there's been too much claiming of inequitable conduct for the use of the doctrine. Another important policy implication of the power of the inequitable conduct defense is that because the most common claim of inequitable conduct surrounds the failure to disclose relevant information, almost always relevant prior art, the incentives that the inequitable conduct doctrine establishes for patent applicants are to, in a sense, disclose prior art, just so that they cannot be accused, or that any accusations later of not providing the relevant prior art are less powerful, that they in a sense can over-disclose to the PTO concerning the prior art that might be relevant, that they're aware of. That has the effect then of making the PTO's job in some sense even harder, because they are now instead of having a fairly narrowly tailored set of prior art from the applicant to consider, they may be buried in huge numbers of not particularly relevant prior art that the patentee or the patent applicant has disclosed merely because of an abundance of caution related to that. So there are significant policy implications to the power of the inequitable conduct doctrine. So it is important to note that inequitable conduct is different than fraud, right? So inequitable conduct is not quite the same as fraud. There is a doctrine of fraud in procuring patents known as Walker process fraud. Walker process fraud is actually an antitrust violation, and we'll talk about that later in the course when we discuss antitrust violations with respect to patent. Inequitable conduct is sort of a junior varsity version of fraud. The fraud in procuring patents requires a much higher standard of intent and materiality, as we'll find out in a moment. And so inequitable conduct is somewhat lower level of misbehavior than out-and-out fraud in procuring patents, which is known as Walker process fraud. So the basic rules of inequitable conduct are this. There are two components to any inequitable conduct analysis: materiality and intent. Right? Materiality refers to the idea that whatever activity, whatever bad act occurred was material to the patent prosecution, and intent refers, of course, to a mental state issue. Right? And this is all done in a two-step decision-making process. The first step is establishing that baseline levels of materiality and intent exist, right? You have to find in each case materiality and intent. There has to be intent, there has to be materiality. That's a fact. Those are factual analyses. Often they're sent to the court or to the jury to determine whether there's materiality or intent. The second analysis is to balance materiality and intent to determine the equities involved, and that's a discretionary call, right? So once baseline levels of materiality and intent are established, then the court gets to decide whether it thinks on the basis of equitable principles inequitable conduct should apply. As a practical matter, once baseline levels of materiality and intent are found, then courts almost always will determine that there's been inequitable conduct, right? So the real action here is almost always with respect to step one, which is determining the levels of whether or not materiality and intent actually exist in the particular case. So let's talk about intent. So the important thing to understand about intent is that, as described in Therasense, the intent requirement is a specific intent to deceive the PTO, right? It's not a generalized intent. It is not mistaken non-disclosure. The Kingsdown case stands for the proposition that gross negligence, even terrible incompetence, is not sufficient to show bad intent. There has to be some sort of a specific intent to deceive the patent office that can be shown. Now, how do you prove it? Well, as the court notes in Therasense, in most cases, this will have to be proven through circumstantial evidence. And that is because it's very rare that you would find, for example, a memo written into the file saying, let's deceive the PTO, right? People aren't going to do that. Instead, you have to try and show a specific intent to deceive given the facts and circumstances surrounding the prosecution, right? So this is found on page 10 of the supplement towards the bottom first column. The court in Therasense says, because direct evidence of deceptive intent is rare, a district court may infer intent from indirect and circumstantial evidence. However, to meet the clear and convincing evidence standard, so you have to show clear and convincing evidence, the specific intent to deceive must be the single most reasonable inference able to be drawn from the evidence, right? So it's a clear and convincing evidence standard, and you can use circumstantial evidence, you can infer from the facts and circumstances, but the inference has to be the most reasonable inference involved, right? And so the court actually on the next page, or on the next top of the next column, specifically says when there are multiple reasonable inferences that may be drawn, intent to deceive cannot be found, right? So the idea of Therasense here is it's trying to crank up, in some sense, the intent requirement to make sure that the intent is not only well above gross negligence, but pretty much the only reasonable conclusion that can be drawn given the facts and circumstances in front of the court, right? So that's the intent standard. The other thing that's important is because the party is what the court in Therasense says, the party alleging inequitable conduct bears the burden of proof. The patentee need not offer any good faith explanation unless the accused infringer first proves a threshold level of intent to deceive by clear and convincing evidence. The absence of a good faith explanation for withholding a material reference does not by itself prove intent to deceive. All right? This is an important statement because it says that even if you withhold a reference or you fail to disclose a particular prior art reference that it turns out you probably should have disclosed, even if you don't have a full good faith explanation for why you didn't disclose it, that in and of itself cannot be intent to deceive. It has to be something even more than that, right? There has to be more evidence than merely the fact that you didn't disclose a reference and you didn't have a good reason not to. There has to be more evidence than that. So this raises the bar, right? Particularly for the typical inequitable conduct case that used to come around, where the allegation of inequitable conduct would be based on the failure to disclose relevant prior art references. This tightens up that standard considerably, right? So materiality, it used to be, the standard used to be the following, right? And Critikon used to set the standard for materiality. And basically, the materiality standard was, in a sense, outsourced to what the PTO declared to be material evidence, right? And before 1992, the PTO's internal rules said that references that were material were important to a reasonable examiner. After 1992, the court said, well, the information that's material to us is anything that establishes a prima facie case of invalidity or refutes some argument put forth by the applicant, right? Those are supposed to be almost the same, but the wording is slightly different. The idea here is the PTO had a fairly broad sense of what was material, which you can understand from the PTO's perspective. They wanted people to, when in doubt, disclose to the PTO. If you weren't sure whether that reference was relevant or not, the idea is you have to disclose to the PTO because they think it's material, and that it's not merely whether or not the patent would have issued or not. And so that was the standard for materiality for a long time, right? Therasense, however, changes that and changes it fairly dramatically, right? Instead now of using the PTO's standard for materiality, what the PTO would consider important to the prosecution, the standard is now a but-for, right? This is a but-for materiality. And what the court says, in assessing the materiality of a withheld reference, the court must determine whether the PTO would have allowed the claim if it had been aware of the undisclosed reference, right? So this is very clearly a but-for analysis, and dramatically raises the bar for materiality, right? And so a big question after Therasense and sort of the debate in patent law circles is there anything left of inequitable conduct, right? Because if it's the case that it's a but-for test, and the but-for analysis is whether or not the PTO would have issued the claim given the reference, well, you have the reference, so if it was, if the reference is good prior art, then that claim should be invalid, right? And so maybe inequitable conduct is essentially gone because in any case in which inequitable conduct would apply, the claim is invalid anyway, so why bother with inequitable conduct, right? So I think that's a good point, and it's probably partially true. And it certainly is the case that invalidating, that basically it sets a standard that any withheld reference would have been likely to invalidate the patent. However, note that the standards of the PTO are slightly different for the way that they prosecute, slightly different than the way that courts would analyze validity. For one thing, as we've talked about before, the Patent Office has a standard of broadest reasonable claim construction rather than the claim construction standard that the courts use. So for that reason, the PTO would probably sweep in slightly broader a broader array of references than would a typical court. And the evidentiary standard is slightly different, right? At the Patent Office, questions of fact are evaluated under a preponderance of evidence standard, right? So where there are validity questions that involve factual issues, the PTO is going to evaluate them under a preponderance of evidence standard. Once you get out of once the patent has been granted, and it's a clear and convincing evidence standard in order to get a patent for those factual analyses, which means that the standards, because those evidentiary standards are slightly different, what the PTO would be somewhat more likely to reject a patent claim than a court would be likely to invalidate it. So for that reason, it isn't the case that what Therasense has done is completely cancel out inequitable conduct. So in theory, there's room left for inequitable conduct because the standards by which the PTO evaluates claims are slightly different than the way that courts would. But for practical purposes, Therasense really dramatically limits the impact of inequitable conduct, and it's going to be very difficult going forward to try and win inequitable conduct cases on that basis. So one important aspect of Therasense is the materiality standard is relaxed, right? The materiality, this but-for materiality standard is relaxed for any particularly egregious conduct, right? So there's a very high materiality standard for cases in which the claim is based on withheld references. If the claim of inequitable conduct is based on, for example, filing false affidavits, right? You say that you invented your invention on date X, and it turns out to be a false affidavit that you filed. That's a different kind of conduct in the view of the Therasense court, and that materiality is not as important, right? And so to some degree, that may, resurrect some aspects of inequitable conduct, but these are pretty rare. This type of egregious conduct is pretty rare, frankly, and so it's not clear how much this is going to resurrect real claims of inequitable conduct. I think what the court in Therasense was clearly trying to do was limit the impact of the doctrine without completely destroying it. So there's a variety of debates among the Federal Circuit judges concerning this change in the law. O'Malley argues that she thinks that the court should be more ambiguous about exactly what is and what is not inequitable conduct, and that in the context of a doctrine which is intended to force patentees to behave well before the PTO, that it might be good policy to not be 100% clear on exactly what types of behavior will and will not be punished. The idea being that if you're a little bit vague about what's going to get punished, people are likely, in order to avoid punishment, to behave perhaps better than they would than if you set out very firm standards, which they then could carefully avoid. And so that's, I think, a good point, and you can decide for yourself whether you think that's a good argument or not, but that's her point. Bryson dissents from this and joined by Garissa, Dyke, and Prost, so it's a very significant dissent. And basically they argue that this is the wrong thing to do, that this but-for materiality standard is a dramatic change in the law. It's going to essentially eviscerate inequitable conduct. Bryson says there are ways, either by raising the intent standard slightly, by tweaking some of the evidentiary rules, that you can use the PTO standards of materiality back to the Critikon case, the Rule 56 of the PTO, where they said that what the PTO considers material are things that are important to the reasonable examiner, the Bryson and Garissa and Dyke and Prost think is the best way of dealing with this issue, and that inequitable conduct can be substantially reformed without resorting to the but-for materiality test, which is effectively going to destroy the usefulness of inequitable conduct overall. So a few hypotheticals, I think, to work through are helpful, right? So halfway through the prosecution process, you find relevant prior art. In order to avoid slowing the process, you simply amend the claim to avoid the art. Everyone agrees you are successful in doing so rather than notifying the examiner, right? Is this inequitable conduct? So this is one of those cases that I think after Therasense has changed. I think pre-Therasense, this is inequitable conduct, right? The idea is that it would still be, even though you probably avoided the prior art by changing your claim, it would have been important to a reasonable examiner. It would have been close enough of a call that the patent office would have wanted to know about this piece of prior art. After Therasense, however, where we have a but-for materiality standard, the fact that everybody agrees that you are successful in avoiding the prior art by redrafting your claim, that means there's no inequitable conduct by withholding the piece of prior art, right? No harm, no foul, no inequitable conduct, I think, in case one in the post-Therasense environment. Case 2, after finding relevant prior art, you file a notice with the PTO listing the problematic reference together with 350 other less relevant but not irrelevant documents. Is this inequitable conduct? So this is, I think, the tricky area I was talking about earlier, where you obviously, given inequitable conduct, have very strong incentives to disclose very broadly, make sure that you aren't being accused of withholding references. At the same time, you can imagine it's possible to effectively withhold references by simply burying the patent examiner in so many references that he or she cannot effectively evaluate them all. I think that post-Therasense, the incentives to over-disclose are going to be significantly tempered, so it's not clear whether this will still be a problem. The Federal Circuit has, on several occasions, noted that it might be inequitable conduct. This is all pre-Therasense, of course, that it might be inequitable conduct to try to, if it appears that you were burying the PTO. And again, I think if you could find some sort of specific intent to deceive, and that whatever you buried was, likely to invalidate the patent claim, then that would be inequitable conduct. Now, I think having a good faith reason for why you submitted so much art goes a long ways towards negating any specific intent finding, right? So the fact that you submitted the quantity of art to impress the examiner with the scope of your prior art search probably gets you off the hook in a post-Therasense world where a very specific, actionable level of intent is required. Case 3, the inventor of the patent application you are prosecuting tells you that she does not know of any relevant prior art. Accordingly, you don't notify the PTO of any. After the patent is issued, it becomes clear the inventor did know of relevant prior art. Inequitable conduct. So one point made by this hypothetical is that the standard for candor and honesty with the PTO extends to everybody involved in the patent application. That means not only the inventor, but that means the prosecuting attorney. It means everyone else involved in the prosecution process. So if there are multiple inventors, each inventor is required to behave with a good faith and have a duty to provide the PTO with relevant information. And so the fact that the inventor didn't tell you, the prosecuting attorney, that something that she knew of something does not insulate the patent from potential unenforceability due to inequitable conduct. However, I think, again, in Case 3, Therasense is very likely to insulate this from inequitable conduct. Again, the question would be whether or not this piece of prior art that is relevant would actually invalidate the claims. Now, the fact that you, the prosecuting attorney, didn't know about it makes it somewhat more likely that the relevant prior art would invalidate the claims, because it would probably have been hard for you to draft around this relevant prior art if you didn't know anything about it. But I think unless you can show, but if you can't show that it would have invalidated the patent, then it's unlikely that under Case 3 in the post-Therasense world that this would be inequitable conduct. Turning now to experimental use. So the basic idea behind the experimental use defense to infringement is that not all uses of a patented invention should necessarily be considered to be actionable infringement, right? And this comes from some of the very earliest statements about the patent law, 1813, for example, the Whittemore case. It could never have been the intention of the legislature to punish a man who constructed a machine merely for philosophical experiments or for the purpose of ascertaining the sufficiency of the machine to produce its described effects. Right? And so the idea here is that for truly experimental purposes, there shouldn't be any liability for patent infringement. Now, of course, the trick is, what do we mean by purely experimental purposes? How broadly does that cut? And that, of course, is the tough question in the context of experimental use. There are two forms of experimental use that are important to understand. One is statutory experimental use under 35 U.S.C. 271E, and the second is common law experimental use. And we'll take the statutory experimental use first. Right? 270E1 says, it shall not be an act of infringement to make, use, offer to sell, or sell within the United States or import in the United States a patented invention and then you can skip the parenthetical, which deals with a very particular type of technology, solely for uses reasonably related to the development and submission of information under a federal law which regulates the manufacture, use, or sale of drugs or veterinary biological products. All right? So this is a very specific statutory exception to infringement for uses reasonably related to the development and submission of information under a federal law which regulates the manufacture, use, or sale of drugs or veterinary biological products. Basically, the FDA drug approval process is what Congress is getting at here, right? So uses reasonably related to the FDA drug approval process are accepted from infringement, right? And that's what we call statutory experimental use. So the important case dealing with this is the Merck versus Integra case, right? And in Merck versus Integra, the defendant used the patented invention as a control, as a series of positive controls when screening for the efficacy of new drug candidates, right? And so the key question the Supreme Court had to answer is this avoid infringement under 270E1, right? So looking back at 270E1, is this the use of the patented invention as a control for screening for safety and efficacy, is it reasonably related to the development and submission of information under federal law which regulates the manufacture, use, or sale of drugs under the FDA approval process, right? And what Integra says, of course, is that this does not fall within 271E1, right? Why does Integra say that? Well, what Integra says is that the 270E1 exception extends only to the FDA requirements for safety type clinical trials, right? And that what 271E1 gets to is to basically accept infringement for certain types of safety-related information that has to be given to the FDA in connection with drug approval, but it does not extend further into more general research or experimentation, even if that research or experimentation is in some sense related to the FDA approval process. That is it's screening for particular drug targets that would ultimately be utilized in the FDA approval process or would support the later approval of a drug candidate in the FDA approval process, right? And so Integra says first that that's all that 271E1 extends to, only safety information. Their second argument is that this type of experimentation, right? These are relatively casual experiments here. They were just screening for safety and efficacy, actually more efficacy than anything else. These are fairly casual experiments and not the sort of formal clinical trial operations that would be required under the FDA approval process, right? And so they weren't conducted, for example, under the FDA good lab conditions that would be required for clinical trial. They didn't have formal control groups, although they certainly had some, but it wasn't quite the same. And so what Integra is arguing is because of that, this is not falling within the statutory exception. Right, and so that's the question that the Supreme Court dealt with, right? But what they said is they agreed with Merck, and they read 270E1 broadly. The Supreme Court said as follows: that properly construed, 270E1 leaves adequate space for experimentation and failure on the road to regulatory approval, at least where a drug maker has a reasonable basis for believing that a patented compound may work through a particular biological process to produce a particular physiological effect, and use the compound in research that, if successful, would be appropriate to include in a submission to the FDA. That use is reasonably related to the development and submission of information under the federal law, right? So this is a broad reading of 270E1. It allows for not only an exception to infringement for information that's specifically required under FDA rules, but it also allows for people to experiment fairly broadly using patented inventions as long as the goal of such experimentation is related to a submission that could be made to the FDA at some point in the future. So basically, drug candidate research has a fairly broad exception under 271E1 for experimentation, for pure experimentation. And so that was a fairly broad reading of Merck for those purposes. So the other component of the other type of exception, experimental use exception, is best understood in the Mady versus Duke case, right? Here, the court holds that this is the issue here. So in the mid-'80s, Mady was a tenured professor at Stanford. At Stanford, he was working on lasers. And at some point, he left to leave Stanford and took a tenure position at Duke. And he moved there. He moved his lab. He had a free electron laser lab from Stanford to Duke. Had a lot of equipment requiring Duke to build, in addition to its physics building, to house his lab. And he obtained sole ownership during this time when he was at Stanford of a couple of patents that were practiced by some of the equipment that Duke installed in the lab, right? Eventually, Mady left as the director of the lab. However, the equipment that he was using as part of his research was still there. And he asserted patent infringement against Duke for the use of the equipment which practiced his inventions. Right? He had patented a couple of the techniques and the equipment used in those inventions. Duke defended, saying that this was experimental use, and therefore they did not need to pay him any money and could not be enjoined, was Duke's argument. Right. So the court here deals with the common law experimental use exception, right? And this is not statutory based. There's nothing in the statute that says there's an experimental use exception other than 271E1, which we've already discussed and deals solely and directly with drug approval information. Here, this is the question is about this more general concept of experimental use. And the court holds that this is both an exception and a defense, and it's not simply a affirmative defense. And so this is important because this changes to some degree the burden that's going to be borne by each party. Finally, return to prior user rights, which is a relatively recent emergence of a defense to patent infringement, right? This is in particular, so there's been a prior user rights defense that was instituted in the early 2000s. That, however, was directed solely to business method type claims. The new one that we're going to study here today in 273 was introduced in the American Invents Act of 2011 and broadens the scope to all types of patents, although as you can see, the types of activities are somewhat limited, right? So the key to the prior user defense is found, or the statutory language is 273. In general, a person is entitled to a defense under Section 282B with respect to subject matter consisting of a process or consisting of a machine, manufacture, or composition of matter used in a manufacturing or other commercial process that would otherwise infringe a claimed invention being asserted against the patent. Now, a person, if such person commercially used the subject matter in the U.S., either in connection with an internal commercial use or an actual arm's-length sale or other arm's-length commercial transfer of a useful end result of such commercial use, and such commercial use occurred at least 1 year before the earlier of either the effective filing date or the date on which the claimed invention was disclosed to the public in a manner that qualified for the exception from prior art under Section 102B, right? So again, basically a year before the effective filing date or the disclosure date of that the patentee provided for the patent invention, for the invention. So let's unpack this a little bit, right? So the first first part of A there has, I think, a fairly limited subject matter application, right? I think there's some debate about this in patent law circles, but I think the best way to read 273A there is that the exception is drawn to either processes or a machine, manufacturer, composition of matter used in a manufacturing or other commercial process. The idea is that these are supposed to be primarily process-based inventions or other types of inventions which are used as part of a commercial manufacturing process, right? And so that's the scope, right? So it's not every kind of patent that's going to be eligible for a prior user rights exception. It's just those that are related to processes or internal commercial process, or things related to internal commercial processes. The part one there requires some sort of commercial use. Well, what does it mean by commercial use? Well, you're either actually commercially using it internally, right? So you're actually running a machine or something, or running this process inside a factory, or you are in some sense commercializing the use of the process by selling the output of the process, right? So again, I think what the idea that Congress has here is that there are certain types of inventions or certain types of activities, internal commercial processes, plant operations, procedures inside your manufacturing facility, other types of things that ordinarily many people would have kept secret and used trade secrecy in order to protect these. And if somebody ever tried to patent them, then they would be able to use, under the old rules of prior inventorship or prior public use, would be able to show that in fact these inventions had already been used and therefore were in the ordinary course of business, and therefore were prevented any patent from issuing that would prevent them from being able to continue the process, right? What I think happens and what Congress was persuaded by was that in a world where those old rules with respect to novelty have gone away and been replaced by the first to file system, which is much more focused on when there's actual disclosure of an invention in a very public way, that there was the possibility that companies would be in a sense caught unawares by people patenting what were otherwise internal commercial processes. So the timing of the prior use, so it has to be a commercial use. The timing of the prior use is a year before either the filing date or the date that the patentee discloses the invention him or herself. Right? That's the basic set of rules. There's a number of important limitations and exceptions to this rule. First, it's a defense. Right? It does not invalidate the patent. Right? What does that mean? Well, that means that if I can take advantage of the defense because I have had this internal commercial process, that doesn't affect somebody else. Right? It doesn't necessarily mean that anyone else is going to be able to avail themselves of this exception or defense. It just means that I get to avoid infringement because I was a prior user. Right? It's personal to the user. Right? That's similar to what I was just saying. It is not something that is a blanket exception for all types of infringement. It's personal to the person who is actually making that prior commercial use. You can only transfer this defense if you transfer the entire enterprise. So if I sell my company and that company was a prior user, as defined by 273, then that the right to avoid infringement will follow the company, but I can't sell just the right. All right, I can't go and say to somebody else, well, you pay me a couple $100,000 and you can have the right to avoid infringement because of my prior user rights. You can't sell your prior user rights unless you're transferring in good faith the entire relevant enterprise. Fourth, the defense applies only to those sites where the prior use occurred, right? So what this means is if you had a plant, for example, that was running using an internal process that later on was patented by somebody else, and you wanted to avail yourself of this defense, you could, but only with respect to that plant or those plants which actually were using the process. You couldn't build new plants after the fact and in those new plants take advantage of the prior user rights, because you would not be a prior user in those new plants, even though you, as the entity, would be able to avail yourself of the defense. In some places, you can only avail yourself of the defense in those places where the prior use actually occurred. Fifth, you can't have derived, right? You remember derivation from Section 102. Derivation is when you've essentially obtained the patented information, the patent information from the inventor, him or herself, or abandoned the use, right? You can't have abandoned the use, given it up, and still avail yourself of the prior user right defense. So you have to be continuously using it during the relevant time periods here. Interestingly enough, there's an exception here. You can't assert this defense against universities. It's not entirely clear to me why this is important. I guess it might be that there's the idea that universities might be particularly vulnerable or particularly late to being able to apply for patents and therefore needed a special exception here. But in any event, there's an important limitation that university patents that are owned either by universities or by tech transfer offices can't be accepted in this way. And finally, and perhaps most importantly, if you assert that you're a prior user and that you can get this defense and then you lose, you can't prove it, or you otherwise lose the case in terms of showing yourself to be a prior user, then the case is exceptional. What does that mean? Well, exceptional cases in the patent law, we'll talk about this when we get to damages, typically mean the damages are going to be tripled. So this is a big downside. So if you assert this defense and you lose it, then that's a very significant downside of losing it, which means that any damages that you might have incurred are going to be substantially enhanced as the result of you losing your claim to the defense, right? So that, I think, is going to dissuade a lot of people from making assertions about this defense unless they're very sure that they're able to prove that they are a prior user and that all of the exceptions don't apply. So the policy considerations about prior user defense rights are interesting. I gave you a short excerpt from the PTO's report to Congress, which was mandated by the American Invents Act, that they had to report about the prior user defense. And the USPTO argues that it's a important thing to have in the first to file system, again, because of their view that there are probably a number of companies who ordinarily keep internal processes, manufacturing processes, as trade secrets, and that under a first to file system, those companies might be particularly vulnerable to sort of being trapped by somebody who comes along, patents a particular internal process, and then turns around and sues them, and that this is a way of avoiding that type of unfairness. So how will it change incentives versus with respect to trade secrets versus patenting? I mean, I think that's an interesting question, and one that is sort of the most important aspect, right? On the margin, it's probably going to encourage secrecy, right? Because if you know that as long as you continue to use this process, that you won't be enjoined from continuing it, there won't be any damages associated with it, even if somebody else comes along and ultimately patents it, then you're gonna, I think it incentivizes the use of secrecy more than it otherwise would, especially for those types of processes and methods that clearly apply under this statute, right? On the other hand, there are still many benefits to filing a patent, even on these internal processes, and there were before, and there certainly are now. And so it's not clear how much difference this will actually make, but on the margin, it probably eliminates some of the downside of keeping something secret as opposed to patenting it, and so in that sense, it probably enhances the incentives to choose trade secrecy over patent in some contexts. So will it have distributional consequences? Right, and so that's an interesting question as well, because and one that the PTO wrestled with. So on the one hand, the defense might be more likely to be asserted by, for example, a small company that perhaps didn't have the resources to file for a patent on its internal processes. On the other hand, companies most likely to have internal processes related to their manufacturing are more likely to be large companies. And indeed, there's a fair amount of research that shows that small companies will often rely more heavily on patents as opposed to trade secrecy because it's easier, because patents offer more protection than trade secrecy, and large companies don't need the protection as much as they just need the freedom to operate. So I think the distributional consequences of this defense are very unclear. The PTO essentially says as much, just says there's no evidence that it's going to tilt the field one way or the other, and I think that's probably a fair statement. I think we don't really know what the distributional consequences are. I do think that ultimately this is going to make trade secrets at least marginally more attractive to companies. On the other hand, I think that there is very strong incentives, and there are very strong incentives to go and take out patents for even your internal processes, because that gives maximum protection, doesn't force you to rely on any particular defenses, and indeed might allow you to later on commercialize the particular process in a way that you perhaps didn't expect.